It's a MEZCAL.
All right, so we look good. All right, good morning, everybody. Today's date is October 25th, 2023. And everyone can hear me all right, correct? Sound good. So this is a regular meeting of the members of the State Liquor Authority being conducted in New York City with video conferencing to Albany and Buffalo. This meeting's also being live streamed on the Authority's YouTube channel, where you can also find recordings of our past meetings. Present today are Chair Lily Fan, Commissioner Edgar De Leon. Staff in attendance, we have Associate Counsel Jamie Gallagher in Buffalo via WebEx. We have Associate Counsel Margarita Marcico in person in the New York City office. We have Juan Herrera from Licensing Bureau. And we have myself, Secretary Roper, via WebEx. And in case you do see something in the background, I have Paula Taylor, who's also in the Secretary's office by me, just kind of watching to see how I do the meeting. So the rest of the meeting dates for the year are November 8th, November 28th, that's a Tuesday, and December 19th, which is also a Tuesday. While in the meeting rooms, please silence your mobile phones and take any phone calls or conversations outside, and please don't touch the microphones when you approach to speak. Items will be called in the order they are signed in, first in Buffalo, then Albany, and then in New York City. The item is called, approach the podium and identify yourself. Representatives should also identify their clients who are present. Chair, do you have any announcements?
Yes, I have a few quick things. As many of our usual suspects know, that we are going through a technological upgrade that is somewhat. I will tell you, I know it's hard to see it from where you are at. It's actually about 95% successful. There are a lot of kinks that, from the user standpoint, it's difficult right now, and we are working on it. All our licensing staff has become software experts. Every day there is an open chat line that is, there's a room that we all go and sit in, and literally everybody is just on their computers and they're working. And then when they have a question, someone will turn their mic on and they will start asking a question and everybody will start listening. I mean, literally, this is a cross-office software solution situation we have going on here. So we ask you for your patience. We ask you for your input. I know that a lot of you have trouble, and do tell us what your trouble is, because that's how we then address them. And it's a multi-level conversation right now between us and ITS, which is the agency that runs these services, and then our vendor, who is extremely knowledgeable and extremely helpful and been working with us for at this point a decade on this. And so we are close to the finish line. We've launched. We are not going back. We are continuing the data transfer, and we are grateful for your patience, and it is going to work. The system works. Our staff is excited about it. With it, we know that there are a lot of things that we can do now that we couldn't do before. We just have to, fix some tools that were not built, because the work is so intricate and there's so many different versions of licenses. Anyway, you get my point. I also want to make two more announcements. One is a happy one. Michael Smith, who has been with our agency for 17 years, just had a baby this year. It's getting promoted to Director of Licensing Services. Many of you know Michael Smith as the guy who is, talking to the constituents, talking to the lawyers, talking to the elected offices, and but many people actually don't know what he looks like. Most people just talk to him on the phone, but now he's going to be a lot more visible. He's going to be traveling to our offices. He's going to try to help streamline our licensing services and our decision making. And obviously, he's been a crucial part of this LEAP upgrade, and will continue to be part of the solution yeah, I'm taking charge of trying to figure out what the solutions are. Let's put it this way. The next big announcement I have is that full board, Mr. Romano here emailed me this morning and was like, hey, you don't have your full board room, which it's not true for today. We did get it back for today, but you guys can see that there are signs out in the hallway. We have, this agency has given our third floor office to support the governor's efforts in processing the migrants work permit intake center. There is this intake center that the city is running that the governor has committed resources to helping process, and they're trying to go from 5 applications a day to 100. If they can get to 500, they can process a lot of these families. There are 22,000 families that they're trying to process. And, you know, the SLA is giving our space to support that. And so moving for the next 4 board meetings, we are going to be voting upstairs on the 8th floor. You will sit in the lobby. We will provide technology so you can still see what's happening, but we will be in a conference room on the 8th floor, and you will basically be escorted in case by case. We're just going to do it that way. You know, it's kind of the way we used to do it in Albany, but we don't want to move to Albany because we still value the in-person, so that, you know, we're not, and it seems silly to ask Commissioner DeLeon to go to Albany at the time when then all of you will appear here probably anyway. And so you see a little bit of, we're trying to practice how this will go. And that's why Donald is also up in Albany trying to run this with his staff here, because I'm trying to save us some resource as well. You know, he doesn't need to come down if we can achieve this way. So just for 4 meetings, we're going to be upstairs. For your experience, it's going to be, you know, we're not going to have this room, but I think this is for a good cause, and this is what our agency can do to support chambers. So that's what we're doing. Moving forward, we will also have a game plan while we address LEAP. The agency also fully embrace that we have a backlog and we have a game plan to try to address that. So you will be seeing some, you know, perhaps some delegations or advisory, something related to that in the next couple of meetings. So I would be on the lookout for that if you're interested in what that process is going to be. And we are very hopeful that once we start that process, we will be on the other side of this problem very soon. And while we're here, I will also address that this is a very small calendar. So, you know, I want to address the backlog, but we're at the bottleneck. We're at a bottleneck. We are really, the staff is really, you know, trying to devote their time. They're covering each other. Permits, as you know, it's really delayed. And so we only have so many people working. So right now we're dealing with a bottleneck. So today will not be here for long. But, you know, we will keep these meetings going, and you know, we'll get there. We'll get there. We'll, you know, in about 9 months, 6 to 9 months, we should be in a much happier place on all fronts. So, having said that.
All right. So first item is in Buffalo. That item number is 1214 RTR8 Limited. That's Snuggeries. Good morning. If you can just introduce yourselves.
My name is Richard Ryder, and this is my wife Patty Ryder, Patricia Ryder.
I feel like it's high. Hey, Jamie,
Yes.
They have some minimal COVID history. I feel like this is their first sale. Can you just double check and see if that's the case?
No, that's correct. The reason for the penalty is because of the prior disciplinary matter within a 5-year time period.
Okay, since it's a COVID, I'm gonna take it to 3,500 if the commissioner agrees.
I will agree with 3,500.
All right, sir.
Yep, thank you. So you'll get a disposition letter in the mail with the new civil penalty
Okay.
and with instructions on how to.
That's it?
That's it.
3,500 would be the fine.
Yes, instead of 65, 30.
Thank you very much.
Yep,
Yep.
thanks for coming in.
Uh,
Try to get a scanner if you can, sir.
Will do.
Oh, yes.
Okay, thank you.
Next in Buffalo is 1199 Tipsy Liquor and Wine Inc.
Good morning. My name is Tracy Jong. I am the representative, and with me I have Jagdish Kaur. She is the applicant, and with her also is her husband Mandeep. He is here because English is not necessarily her first language, and he may need the help in answering any questions that the commissioners may have. So we're here today on an application for a new liquor store. This liquor store is proposed to be located as a self-standing building at the corner of two major roads at an area that is basically the intersection of Brighton, Henrietta, and Chi-Li. So there are some other liquor stores in the area several miles away, but they're down near some very commercial strip mall areas and near two of the other exits to 390. This is at the far west end of town, and it's closer to one of the exit that most people are getting off to go to RIT.
Can I just stop you for 1 second? So
Yes.
you mentioned that, what, is he interpreting for her or he's not interpreting for her?
He
It
will
doesn't
be
matter.
interpreting. He will be interpreting for her. She
Okay,
speaks
so
some limited English.
Okay, but then he needs to be interpreting what you're saying as well, just so that the record is straight.
Yes.
Yes, sir, can you put first your name on the record as the interpreter and then just interpret it what she's just said?
Okay. Mandeep, that's my first name, and last name is Singh, S-I-N-G-H.
Okay, awesome.
Okay.
They want you to restate what I said to her.
Okay. Actually, she ਦੱਸ ਰਹੀ ਹੈ ਜਿਹੜਾ ਲਿਕਰ ਸਟੋਰ ਹੈਗਾ ਦੋ ਮੇਜਰ ਇੰਟਰਸੈਕਸ਼ਨ ਹੈਗੇ ਨੇ ਚਾਈਲਾਈ ਬ੍ਰਾਈਟਨ ਤੇ ਹੈਨਰੀਆਟਾ ਦੇ ਵਿੱਚ ਠੀਕ ਹੈ ਉਹ ਦੱਸਣੀ ਪੈਂਦੀ ਤੇ ਉਹ ਸ਼ੀ ਇਜ਼ ਐਕਸਪਲੇਨਿੰਗ ਬਿਕੋਜ਼ ਦੇ ਅਦਰ ਜਿਹੜੇ ਹੈਗੇ ਨੇ ਲਿਕਰ ਸਟੋਰ ਕਮਰਸ਼ੀਅਲ ਏਰੀਆ ਚ ਹੈਗੇ ਨੇ ਮੋਸਟਲੀ ਰੈਜ਼ੀਡੈਂਸ਼ੀਅਲ ਏਰੀਆ ਚ ਹੈਗਾ ਯੈਸ ਥੈਂਕ ਯੂ
Yep. All right, keep going, ma'am.
So, as I said, Henrietta is a very big area. This area where this is located is generally mostly commercial. There's not a lot of residential. It's near RIT, the campus, but the area is mostly, and there are some commercial buildings, but mostly it's businesses and industrial that are along East River Road and also, what is the road across the?
Scottsville.
I'm sorry, and across Scottsville Road. So,
Jamie, there's no protest there, right?
No.
there's no protest.
Nobody.
And Donald, I don't see any protests on the record.
Okay. Let me pull that up. Make sure.
Is that right?
Sorry, let me pull that up right quick. If it's not in your materials, then no, there wouldn't be any. And there wasn't any supplementals. So now it says no. There's been none.
It's 2 months away, that's the only thing. What kind of conviction is that?
Would the board like me to address the conviction of the husband?
Please do.
He had a felony conviction many years ago to do with, they had some large marriage ceremonies that were done for Indians, and some of the people were permanent residents, some of them were immigrants, and there were charges because of these marriages. They were arranged marriages, but at the time they took it as if they were trying to bring illegal aliens to the U.S. It wasn't the case, but he didn't defend himself at all. But if you, we have the charges and all the records in here, but you can see it has to do with large marriage ceremonies for within their culture. So there were charges against everybody who was involved in these arranged marriage ceremonies.
I understand, but he still has a felony conviction, and that is a bar to him being licensed. I also understand.
He's not the one asking.
I also understand that. I also understand. I wanted to make sure that he's not going to have any part of the business. I do have a concern that apparently the applicant does not speak English. Now, if the application says they're going to be 3 employees, are any of them going to speak English?
Yes, the employees do speak English. They have many businesses, and they've had other businesses in this area in retail. They recently had a restaurant that a lot of their employees were local people, as well as their own children, which are speak. Their entire family generally speaks English and works in these businesses with it. So, but they have successfully held other licenses. She has most recently had one a few miles away. She sold that restaurant to another family member to apply for this liquor store. So they certainly have a history of her operating the retail business herself, and no issues with compliance with the liquor authority or, with English. Mostly she's back in an executive capacity, not the one at the register.
Okay.
The husband, that's Mr. Singh who's present, correct, with you right now?
Hey, Margarita.
That is correct.
Can you look
That
and
is
see
correct.
if she has any COD?
Stores, one did not respond. Actually, 2 did not respond. One shows projected increase, significant increase, that's Henrietta, and one shows a significant decrease, White House, in gross sales, or projected gross sales for the end of the year. So I think they kind of cancel each other out. If you're okay with it, I'll approve it.
Okay, great. Awesome. So, since the applicant have experience with our agency and no adverse history, have experience on the retail tier, and then also that closest store is more than 2 miles away and didn't submit numbers, I don't see any protests on the record. Store is relatively small with no bulletproof. I am going to find public convenience and advantage and vote to approve.
I will also vote to approve for the reasons stated on the record.
Thank you.
Thank you for coming in.
Thank you. Thank you.
Yeah.
And Nicole and Jamie, there's no one else in Buffalo, correct?
That's correct.
Yeah, all right. Obviously, we'll leave it up for Jamie. We'll move next to Albany. We have, that's number 1225, Saratoga Hospitality at GAFFNEYS LLC.
Good morning, members. Alexandra Becker of Whiteman, Osterman, and Hanna on behalf of the licensee. You may recall that we were here before you actually in person at the July meeting on the same application, which has been pending now since June of last year, seeking live music and return of patron dancing. When we were here before you in July, there was an issue of whether the city was in support of these changes. I think the board was unable to reach anyone at the time, though they did try to confirm that. We have since been able to provide letters of support, including from the mayor and 3 out of the 4 commissioners, showing that they are in fact in support of these changes. So I would ask that the board today vote in favor of approving this application.
I'm okay. Are you okay?
Well, before, I just wanted to make the board aware that I was in touch with the waiting time.
What's the date of that violation?
I don't have the date. I do know it's an extensive violation where there were.
This was the same problem we had last time. That there were perhaps pending charges.
There were not. As of the July meeting, there were no charges pending. This
I know,
meeting
but
was
now
pushed-
they're saying, now council's office is saying that there are pending charges and you must know about these, right?
We've known about the pending charges. The client actually came up here 2 weeks ago to do this meeting. We were called that morning to be told that charges were pending. We put it off. We actually, in writing, requested copies of the charges from counsel's office a week ago in writing and haven't received anything. So at this point, to the extent that charges are issued, we will absolutely work with counsel's office to resolve those. But we would ask that the board vote on this, which has been pending long before the current charges, which to our knowledge have not yet been issued.
Our main concern is that the licensee to indicate how they're going to conform to.
What are the charges? Can we just take a break?
All right, we're going to go on a brief recess to conference with council. We'll be back on shortly. People can mute themselves. Thank you.
We're gonna call you, Jamie.
Hey, Miss Carpete. Hey, morning. If you could just hang tight, just kind of mute yourself. We'll let you know when the person's ready.
Sure.
Thank you.
Donald, do they need me to go back to the office again?
I don't know. Maybe. Jamie, they're back. Jamie. All right, ready to go?
Yeah, we can wait for Jamie to come back.
Okay.
And Ms. Becker.
She's right there. All right. So we're back on the record after a brief conference with council.
Okay. So you know, we really try to help you in July, and that was actually the best opportunity for you to get the method of operation that you want onto the books. And I think that our counsel had told your client that he needed to be in compliance.
At the July meeting, not to interrupt, but at the July meeting, we had a letter of support from the Public Safety Commissioner, which, based on my prior conversation with council, was not provided to the board. And there was some question at that meeting of whether we had the support of the city. We've now shown that we have the extensive support
Yeah, I
of the
know.
city.
The thing is that I know the problem is now you have pending charges, and you know this is how we operate, is that we cannot give you more method of operation when you have pending charges. I think everybody in the room knows this.
But how can
So,
we address the fact that we've requested
can-
the charges and we're not given the charges, and this just seems to keep perpetuating that they were the victim of a licensing delay in the first instance, that it took 14 months for the application to get back before the board. They've obviously been cooperating with council on charges that were not in play at the time
Yeah,
that we
but
were
I think
originally
that
before you on this
it's-
issue. And honestly, this method of
can send
operation is
you-
frankly
look,
crucial
I
to this
am-
business being able to operate, to be able to address any future concerns or fines.
I can direct Mr. Brennan to email you the actual NOP right now, but I don't believe that you need us to tell you how you're not in compliance.
I mean, having not seen
You
charges,
just
we
want
don't
to know
want to
what
certainly
we
admit to
taught
anything.
you and what we're putting down on paper, but you know how you have not been in compliance. So I can do two things. I can either kick this down further, because you've been dragging 1, 2, 3, 4. I mean, we've kicked this over 5 times for you to do I don't know what. I mean, now you have the support that you want, which I respect, but I can't give it to you right now. So there's a timing issue. So either I kick this all the way down so that you figure out how to resolve your pending charges, and then we can deal with all at the same time, or I don't want to say no to this, because then you waited long enough for me to not do that to you. So
Let's go ahead
what do
and
you
push
want
it
to
down
do?
the road. I just wanted to say that we have not been pushing it off each week by choice. It's been in conjunction with council's office. They've had interviews. We've been complying. This has not been us pushing this down the road intentionally. And we're happy. I think, we would like to keep this moving as quickly as possible. Again, we actually requested in writing that we be provided with the charges. So we would like to keep this moving and would like to obviously resolve this as quickly as possible. So anything that the board can do to facilitate that, we would greatly appreciate.
All right, thank you, Ms. Becker. Chair, do you want to hold it over till the end of the year, or when do you think?
What do you want to do? Because if we can do them a favor and hold it till the end of the year, or we can just deny it, but then they're filing, I mean, they filed this in June of 22. If they have to start over,
Well, I mean, I think they should be given enough to be heard on the pending charges. So make a decision based on what I understand the charges to be, giving them an opportunity to address. So I'm okay with holding it over.
can
if
Bill
you are.
Brennan finish the case by December 19? Is that realistic? Or should I put it January 10?
I mean, doesn't it depend on if counsel's office and the licensee can come to an agreement?
Yeah, it does. But I assume that they're going to come to an agreement. She's saying she's going to come to an agreement so that this can move along. It's
We
going
would
to be a
respectfully request December 19th, and then, you know, we will obviously
Okay.
be using our efforts to resolve it, hopefully even before then.
Okay. All right. Let's hope for December 19 when everything can get done at that same time.
Appreciate it. Thank you very much.
Yep. Thank you.
All right, and Annie, there's nothing else in Albany, correct?
No, that's it.
All right.
You can sign
Donald,
off
can
on
you
the
just
agreement.
call her and just tell her that they need to be in compliance in the meantime?
Okay, yeah, we'll make sure to.
Just
Yeah.
don't have more charges because then it's just going to become a problem.
Okay. All right, Annie, you can sign off.
All right. Thank you. Do we
All
have
right,
an
so-
interpreter?
We do, but the person that needs the interpreter, their attorney's not there yet. It's not in New York City.
Okay.
So the applicant is there, or the licensee is there, but their rep's not there. All right. So first in New York City is 1231. It's a request for a declaratory ruling, 1 West 29th Street.
Morning, Bob. I'm sorry, Bob, before you start, Donald, do you want me to do the,
Oh
Set
yeah,
up now.
I'm sorry, Juan. Yeah, if you can switch the camera so that the stream can see the audience now. But do it where we can see the members also.
Oh.
All right. Yep. So now on the stream, let me make sure it looks good on YouTube. This is just a test because we don't have our little camera down there that we usually use. All right, that should be good enough. All right, so sorry, Mr. Romano, if you want to go ahead and introduce.
Very much, Robert Romano. I'm here with Wendy Rubin, who, I just want to make a small correction on the May 4th letter.
I'm sorry, Mr. Romano, is your mic on? Can you see on the bottom of the microphone for your stand is on?
Now, better?
Yes.
Okay, Robert Romano, I'm here with Wendy Rubin, who I had mentioned in the May 4th letter, which is in your possession. She would be filing for a yet-to-be-formed entity. Since that time, plans have changed, and she has filed a removal application of her current license, which still requires your approval of this declaratory ruling, or a finding in our favor. We're here to answer any
Meaning
questions
that you're going to also still apply for
in the same
at
space.
1 West 29th.
Correct,
You're
correct.
just now
That's
going to do a removal of an existing license instead of filing for a new
correct. It shouldn't have any,
on premise.
it should not have any,
The
it shouldn't
existing
make any
is
difference.
is a full OP
Right.
located where?
Correct. At
1 East 28th Street, around the corner.
the same location that's mentioned in here. It's just the entity that will be going in is an existing entity.
Has the
Um,
application been filed already?
Yes.
We had just filed the removal
Just filed.
application.
About a
Yeah.
month ago.
Yeah, I don't even think we got an application receipt yet. But, so that will be coming up, and obviously, depending on the outcome today of this ruling, we'll have
Get to
to,
the merits of that discussion, being that an application has been filed now. I guess I can be corrected if I'm wrong. Will there be a 200-foot hearing?
There's no 200-foot hearing. Yeah, it's a 500-foot hearing.
Fi- 500.
That's okay. There will be a 500-foot hearing, but we first have to get over the hurdle of the 200-foot
Okay. But
restriction.
there
So
will be a hearing before an ALJ.
Yes, I mean, assuming if you find in our favor today,
Then there wouldn't be.
no, there still would be a 500-foot hearing,
I
but we
guess what
wouldn't
I'm-
have any 200-foot issues.
I guess what I'm getting at
Yes.
is this ruling essentially putting the carriage before the horse.
No.
Why not?
Because without a ruling in our favor, that application's dead.
If you get a ruling in your favor.
We
is the-
move ahead as
Is
if
the application predetermined?
it would be determined by the 500-foot hearing, correct? Correct. So again, we're here to answer any questions, clarify anything you need. Wendy has devoted the last year of her life to this almost 24/7, is extremely well-versed in every aspect of this request, as I hope to be as well. And I think you have everything in our written submission that we were.
I read what you wrote, which is very comprehensive and very well-written. I understand that this is a church that has many, many functions and is apparently bringing in a lot of money for those functions. But just taking from your letter, the question for me is, which is not answered anywhere, either in the report that we have from our agency or from your letter, is what is that money being used for? Because as I understand the law, it says it can be for that church, but it can also be for other not-for-profit organizations or groups. The organization that is conducting these events, what I read, raises money for all of the collegiate churches in the city. And if the church is having, as you cite in there, that they had a movie filming in that church, that filming takes 10 days of filming in that church, but the remaining 20 days are being used for church services and other things related to the ministry, then is the building still essentially functioning as a religious institution, a place of worship, or not? And none of that is addressed in any of the materials that I've seen. There's no indication of how often or how many days religious services are held, how many days other events are held. There's no indication of where the money that's being raised is actually going. And I think the church is an interested party, no? And if we rule without having any input from them, are they in essence being denied the opportunity to notice, opportunity to be heard, classic due process in this process of having a declaratory ruling up front? So those are some of the questions that I had, if you could address them.
Sure. With regard to notice to the church, we can discuss that in a moment. But as far as the money going into the church and being used by the church for incidental purposes or church purposes, I think Wendy can describe that better than I in terms of.
Thank you. Hey, nice to see you guys again. First of all, obviously, we like the church. The church was actually in our space, the one that I'm trying to rent, and they have a great relationship with the landlord. Consequently, us and the landlord were all on and the church, and 3 or 4 members of the church were all on a Zoom about 8 months ago. And the church very clearly said that they support us. In fact, they said to quote, save us a corner table in the bar. Then now we go to John Doe across the street, but save us a corner table in your space. They 100% support us. So if can I continue? Are you okay with that? Okay, I'm a little nervous. Sorry, this is kind of my life and yeah. Anyway, so question 1 is Marble Collegiate Church being used exclusively as a place of worship? From my opinion, it is not. It's that there's a robust, as you know, if you go to the marbleevents.com website, robust events operation that is in the church. If you want to film a movie, like HBO was using it for staging. You can have a lecture, you can have a conference, you can sell tickets at the door for it. You can have your choice of one of 10 rooms, or you can take all 10 for $2,000 an hour. So it is not that it's just a little tiny thing. It is a robust business.
I understand, I understood that from what I read.
Right.
But my question is, how often does that happen? Say on a monthly basis. And
Well,
how-
so,
and how does that compare?
right. Well, we tried to go and book an event to, to go through the process, and we couldn't book an event for months. They were booked out. So fairly often. And I have, the person who did that on my staff, she's got, if you need to see that in an affidavit, she
But that
has.
could be that they limit themselves to 2 events a month, and that could be, I don't know.
Right. No,
I
they
don't have information.
don't. We actually did another tour with the guy who does the events with Rick Carper. And the person who did that tour is also in the room today. And they rent it out as often as they possibly can.
And I'd like to point out, it is, the words in the statute are exclusively, not primarily. And, once you pop the balloon, it's no longer considered a church.
Well, incidental use is permitted, right?
Incidental,
Okay,
yes.
well, that's essentially my question.
Okay.
Is what we're talking about incidental or not? And we don't know. 'cause
As long as that money goes to the church, which it doesn't, it goes to a separate entity.
But that separate entity is an arm of the church, and I believe in the letters that I read, that organization or that subsidiary supported the church.
Not anymore.
No, they don't.
If I can finish.
I'm sorry.
If I can finish. Supported the church during the COVID. And I don't know what other things they do, not just for that church, but for all the collegiate churches, as is specified in the materials that I read. So you can operate a not-for-profit at $1,000 a month, and you can operate one at $100,000 a month. The question is still whether or not you're operating as a not-for-profit, and what are you using the revenue that you're getting for? I think that if it's being used for religious services or for other things that are contemplated in the statute, might be fine, especially if you're still having the majority of the time religious services and other things connected to the church, as opposed to just commercial events. You want to address that?
Okay. Okay, so a couple of things. So the company, the corporation that you're writing the check to, they're called Collegiate Church Corporation, otherwise known as Collegiate Asset Management. They're the real estate arm of the church. They were in 2019 worth $330 million, which is akin to like Remax or Dish or iHeartMedia, actually bigger than Kodak. They are a wholly different company than the church. They use their money differently. Again, their purpose is to buy and sell real estate. That is what they do.
On behalf of whom?
On behalf of the church, but that doesn't mean the money is going to the church. In this case, it's specifically not going to the money. It's not going to Marble Collegiate. If you looked at exhibit number 7, this is from their, sorry.
At the website or?
No, well, yes, this is from their, what's it called? The thing that their financial report that is public. And this is from 2022, and they specifically say that they are no longer being supported at all by CAM, by the Collegiate Asset Management. It's here in writing. It says, sorry. So Marble and each of the 4 collegiate ministries have received substantial support from Collegiate for centuries. Now that is gone. And if you look further into their financials, you'll also see that there's no longer a line item for any money from Collegiate Asset Management. Now they get their money from their own endowment, which is the Collegiate Marble Endowment, which is just donations. So they are not receiving money by the church's own writing, by what they put into the public. They are not receiving money anymore from
There's a
CAM.
process in place to flush out the facts, and I'm inclined to let that process go forward and determine some of the facts that I'd like answers to. So I'm not inclined to issue a declaratory ruling at this time. you're gonna file an application, and it will be from start to end. And I think there'll be an opportunity for a hearing also.
May I ask what, I've been waiting 6 months for this. This is my life on hold, and it's a huge deal to me. I'm trying to change my business model after being closed during COVID. But regardless, I'm so excited and so grateful to be here. And I did all this research last January, and I researched ad nauseum. And if you have questions that are unanswered, please ask them, because I don't know what else could be found other than what I have found. So please let me know what you have a problem with.
I understand that, and as I said, when I started the application, what you put together was very comprehensive, and it's certainly appreciated. I think I'm just not inclined to set kind of a precedent here, where the ruling comes before the actual application, where people who might want to have a say in determination have notice and an opportunity to be heard. That's a little bit of my concern, not to mention that there are just facts here that we don't know.
There's what? I'm sorry, I'm having a hard time hearing.
Facts we don't
Facts that
know.
we just don't know.
Which, surrounding what? I'm like,
We just spoke about. This conversation, is not a hearing where facts are being.
I think, look at it this way. What we're saying is that we don't have enough facts to find that the church is not exclusively used.
Right.
okay,
And instead of giving you a negative decision
Right.
today, we are giving you the opportunity to move forward with your application, get through the 500-foot, and then have the 200-foot evaluation at that time, because at that time, our investigators can go out and do more fact finding and do our research. That's what he's saying.
okay.
The
Very
problem,
positive way of saying what I'm saying.
no, I appreciate
wholeheartedly
that.
agree.
The problem with that is the financial, going forward.
It's your choice to
Right.
move your existing restaurant that is 200 foot outside of a church within 200 foot. That is your choice.
May I
That is not my choice.
address the
The
precedent?
laws are the way they are, and he's reading it the way he's reading it.
Right.
May I address
It's
the
a choice you're
precedent?
making to file for this declaratory ruling. The agent, the
Right. May I address
state
that?
liquor authority does not have an obligation to issue a declaratory
Of course
ruling. And it's better for us to not say no. I mean, we can issue one. He's gonna vote no. So
I understand. Just in the way of addressing your questions, as insofar as precedent, there is a couple of precedent rulings that have been made. You all made one of them. You all did the one that was in 2008, that was in favor of Logan Sanctuary. And you all said that, and this doesn't even have to do with the money, this just has to do with the exclusivity of the building, of whether or not it's exclusively as a place of worship. Again, nothing to do with the money. That, I think that those are both separate points that work in our favor. But you said that there were 2 theater groups operating within the church's premises, that the group's presentations were unrelated to church activities produced for the general public, and that they charged admissions for their shows. And that stopped the church from being an exclusive, being used exclusively as a church. The second,
I read.
right. Well, and then the second one was by the state Supreme Court, which was Le Parc Gourmet versus you guys. The building here involved is being used on a regular basis for a number of non-religious uses of which the church has no control, which, obviously if they're renting out their space, they don't have control. And actually it's fairly ironic that if you do $1 million rider, you can have alcohol in the church. So it's just neither here nor there. It's just kind of an interesting irony. But
I read all that, and I think Chairman Fan
Right.
certainly presented my position.
right. I mean, I appreciate you not nixing us. I just, again, I've spent a year doing this. I don't know what you are going to find that
I don't know either.
that is different than what I can tell you. That
I don't know either. But there is a process, and I'd like to see the process go through.
problem is if we get to that point,
We can't move forward with
Mr.
the lease
Romano
to get to
and
the
ma'am,
500-foot.
ma'am, I'm sorry. I think the members have already voted, correct, Chair?
or
So
Unless you're ready.
can you tell me then what my process is? Because I cannot move forward with a 500-foot hearing. I can't move forward with.
Ma'am,
Oh,
ma'am, I
okay.
think what they're saying, the process is, they're wanting you to go through is file the application. And when the application is filed, they'll go through a 200-foot investigation where an investigator will go out and conduct its own investigation. And the 500-foot
So-
hearing will also take place.
okay.
So I think if the members, if you want to make your votes official, Chair.
Yeah, I'm going to decline to issue a declaratory ruling in this matter.
I'm
And
also gonna
sure.
decline.
Um,
I'm also gonna decline.
Sorry,
Sorry,
so
what
we'll
was
move
the
on to
official-
the,
They said they're declining it?
Declining.
We're just going to
decision.
decline to issue the declaratory ruling as requested.
Okay, okay, thank you.
and Commissioner De Leon, is your mic on? I'm sorry, I think some people are having issues.
Mine is on.
It's on?
Yes. Yeah. Hear me?
Okay.
You hear me, Tom?
Is your mic light, is it green? Is it on?
Yes.
We couldn't hear you, that's fine.
Oh, no?
We had a very hard time hearing you.
Maybe take one of the other ones. No worries. Can everybody hear me now? Can't hear me.
I don't know.
Looks like we're having issues with a couple of our mics.
For the audio, yeah. I mean, it's on and it's great.
Can't even switch it, right?
Yeah. Yeah. Oh, yeah, there's an issue with the mic. Yeah.
All right, so unfortunately, we're gonna have to move forward, but hopefully we can hear you. I can pick you up on the recording. It's just soft. But
Okay.
I don't know if members of the audience can.
Okay.
Can you hear this?
Does that one work over there?
Actually,
Try that one.
hello, Don?
Yeah, that one.
Yeah, this one's.
That one works.
So,
You want to move the mic or you want to move over there?
I don't know if we can move the mic. I'll move over there.
Not
Yeah.
sure if we're able to move it ourselves.
You better not mess with the mic. You better move the human person.
Yeah.
it has to be from the audio.
This is this one.
Yeah, no, yeah, I think it's better if you don't mind.
No, not at all. Yeah.
Oh, are we? Alright, I think we can just move forward with you sitting there, and we'll just have to.
Okay, we're good.
Yep.
All right.
Next is 1228 102 North Franklin Court.
Yes, for the licensee. Good morning to all. My name is Lawrence Carr. I'm the attorney that represents the entity. Additionally, next to me is Isela Amaya, who is the licensee. This matter comes before the board because unbeknownst to the corporation, there was a service of a citation which was not responded to. It comes from an event that occurred in or about June. At that point in time, the Hempstead Police Department were there, citing it as a disorderly premises. The manager who was present did receive an appearance ticket in the Nassau County Court. I appeared on that behalf, and the matter was adjourned to contemplation of dismissal. At no time did the licensee have notice of the pending hearing. As a result of same, a cancellation order was issued. We asked for reconsideration. I did speak with counsel's office, and they indicated that the certified mailing that went out to the licensee was never signed for, and we had no notice that the State Liquor Authority had brought any action against us. Had we been aware of that, we certainly would have taken the necessary steps to ask for a conference and possible resolution of the matter. We stand before the board now. We understand there is a stay. They do have their license. We're respectfully requesting that the matter be referred to counsel's office for resolution. I also did file a notice of appearance, and I confirmed with Mr. Buckley last week that the certified mail either I don't know if it never got there, but it was never signed for, and we had no knowledge or notice of the request from the board.
You guys want it back? Yeah, okay. I'm okay with going back to council's office.
Same here.
Thank you.
Thank you very much.
Wait, so,
Yeah.
sorry. So that's granting reconsideration and returning to council's office?
Yes,
Yes.
thank you.
And Commissioner.
Will I be, one question, will I be notified by mail to reach out to council, or is it now balls in my court and I should contact Mr. Buckley?
It would be best if you could contact Mr. Buckley. If you want to reach out
Okay.
to him, but we can also, I'm sure Margarita can send him an email as well.
All right, thank you for your intervention. I appreciate it.
Thank you.
Have a nice day.
Next is 1230 Serafina to go 30 Broad LLC.
Good morning, members. Max Bookman, Pizetsky and Bookman PC for the applicant, Serafina to go 30 Broad LLC. To my right is Kevin Del Castle. He is the operations manager for Serafina. Commissioner, were you ready for me to proceed, or I'm happy to wait?
Yeah, let me ask you a quick question though. What I read in the application was that the school is part of a very large commercial building. My office is literally right around the corner from there. I walk past there all the time to go to the train. And I see the signs posted on a much smaller building, perhaps 5 or 6 stories, that specifies the school, not the 41-story building adjacent to it.
That's right. Yeah, that's right, Commissioner. The school at issue is the much smaller building that you're referring to. If it was part of the larger building, then we wouldn't be here, because the building containing the school obviously would not exclusively be used as a school. It is the smaller building that's at issue.
I thought I read that the application said that it was part of a 41-story building.
No,
That's
not accurate, no. So if can just step back for a moment. So this is a class change application that's before the board. And the question for the members is whether the 200-foot law prohibits the issuance of a full on-premises license to Serafina, which, as many New York City residents know, is a well-known Italian restaurant, family-friendly brand. So what when we filed the application, we submitted a 200-foot law statement. It was a 3-page legal brief with 16 pages of attachments. Commissioner, if you'd like a copy, I could give.
No, that's fine. We're just taking, wanted to show it to Chairman Pham.
Okay.
Right next to it here.
There it is, much better.
Serafina's would be right here. The application says that it's part of a 48-story building, but it's misstated. Go ahead, sir.
Thank you. So there's 2 separate and independent reasons as to why the 200-foot law does not prohibit the issuance of a full on-premises liquor license to this applicant. We addressed both in the statement we submitted with the application dated January 2nd, 2023. The first reason has to do with doors. There are 2 doors to the school, a near door and a far door. We submitted an area survey that shows that the far door is over 200 feet from the licensed premises. The near door is under 200 feet. The far door is the main entrance to the school. But because it's more than 200 feet, it doesn't matter. The near door is the one at issue. That's the only door at issue. Kevin, to my right, he, in the course of us investigating this issue, went to the school and spoke with the head of security, who greeted him, who advised Kevin that that near door is not regularly used to provide ingress to the school. It is a door that provides egress and occasionally provides ingress for events, but does not regularly provide ingress. That's the statutory standard, regularly used to provide ingress. So even though that door is within 200 feet, our submission to you is that it doesn't count for purposes of the 200-foot law because it does not regularly provide ingress. But we have a second and alternative argument, which is that the entire building, and just to be clear, based on your comments earlier, Commissioner, we're not arguing that the large office building contains the school. We accept that the school is in the smaller building that you referred to. But our submission in the alternative is that that entire building that small building is not exclusively used as a school because of the events that the school puts on. And I want to, before I tell you what those events are, I just want to preface it by saying, I think Mr. Romano's case that we had a few minutes ago provides an excellent comparator to this case, because all of the legitimate questions that you were asking, Commissioner, concerning that church's potential ancillary uses in their events were legitimate and applicable and relevant as it relates to a house of worship, but quite importantly, are not relevant under the statute as it relates to a school. The questions that you were asking came from Section 64A7E of the ABC law, which was an amendment to the ABC law in 2007. That 2007 amendment was specific to houses of worship, and it created an enumerated list of activities that a house of worship may tolerate and engage in within the house of worship without depriving the house of worship of its predominant character as exclusively used as a house of worship. But quite importantly, the legislature did not see fit to include schools in that amendment. In other words, schools are not subject to that list of activities. And so as a result, there's basically two legal standards that have emerged from 2007. One very difficult legal standard for schools, difficult from an applicant's perspective if you're trying to prove non-exclusivity. Sorry, I misspoke. One difficult standard for houses of worship, from an applicant's perspective, if you're trying to prove non-exclusivity, and a less difficult standard from an applicant's perspective for schools. For schools, exclusive means exclusive. And here, what we've submitted to you in writing, and we have ample evidence of it, is that this private school is essentially open for rent for private functions through the three major areas of the private school. They have a large private ballroom, multi-purpose ballroom, which we have photographs of. Their gymnasium and their cafeteria are all open for rent. They do business as the LEHMANN Ballroom. They have a secondary name that they use on social media called Broad Street Ballroom. They have their own separate website, which makes no mention of the school. They have a head of events who you can email. And when they email you back, their signature is LEHMANN Ballroom Head of Events. We emailed them. We have that in our papers to try to book an event. They tell you what their prices are. They give you floor plans for the various areas of the school. They have preferred caterers that they suggest you use. They frequently obtain one-day permits from the authority for one-day liquor events at the school. They have on their social media, which we included, you could see that these events that are held are not events for the benefit of the school. These are not, PTA events or things of that nature. These are really nice, fancy corporate events for lower Manhattan businesses.
Who runs the ballroom? Who runs the space? It's the school employee that's actually doing it?
Well, no. So what they rent you is space. They don't do anything but other than give you the space. If you want to hold an event, you have to hire an outside caterer who's going to come in and do the food. You have to get the
but who am I renting it from? And I'm renting it from the school?
You're renting it from the school. Absolutely. There's no separate entity situation here, as with the prior case you just heard. You're renting it from the school. But what I submit to you is that because the school has such a clear, unambiguous, significant events business that they do. If this was a church, I recognize that would not be sufficient. But this is not a church, it's a school. The statutory standard says exclusively used. There is no additional gloss on that term exclusive from the 2007 amendment like there is for churches. And so it is not exclusively used as a school.
When I was thinking about this, I'm thinking that in 2023, there are a few churches, temples, mosques, synagogues that don't need to, bless you, that don't need to raise revenue other than, by other means other than tithings or, as was done many, many years ago. It just doesn't work anymore. And I think that may also go for private schools. Not all of them, certainly some of them are quite well off. But having other events is kind of become necessary to their survival. Now, the distinction you're making for me that's important is the one between church and school.
That's right, Commissioner. And I would just say to that, respectfully, is that I think what you just elucidated on is really a legislative judgment. And I think that was the judgment of the legislature in 2007 as it related to places of worship for that exact reason. It's quite common, and increasingly so, for places of worship to have a caterer, to open themselves up for private events so they can make money that way. Alcoholics Anonymous meetings, other things that are for the benefit of the church. If you look at the legislative purpose section of the session law that amended the ABC law, that was in fact the legislative finding. But no such finding has been made for schools. And we could hypothesize a legislature making such a finding, but one has not been made. And 2007, of course, is not ancient history. This is recent times. And so what I think the best way for the authority to respect that legislative finding is to give meaning to really what was a difference that was put into the law, a lower standard for churches and a higher standard for schools, or the opposite, depending on your perspective.
Could we take a moment?
Sure.
Chair?
All right, we're going to go off the record for a brief conference with council. We'll be back on shortly.
Jamie, we will go on.
Ms. Gurpreet, I just wanted to let you know, your case where we need you as an interpreter should be next.
Okay.
Thank you for holding on.
No, that's fine. I'm here.
Hey, I think I don't know if we're gonna need to, if we should move those. And I don't want to mess everything up.
you
I
vote?
think we're good.
I just want to say, just to the extent that I've not persuaded you on the second argument, which I think is a legitimate argument, I just don't want you to forget that we still have our first argument, which is that the only door that's within 200 feet is not regularly used to provide ingress.
Look, it's not, that second door is certainly not far away from the first door. But I'm told that there is a distinction, which, you're a good advocate and you pointed that distinction out. And that's an important thing to note. There is apparently a difference between a church and a school.
Yes.
You're also talking about a restaurant here, a well-known chain. So it's not going to be like a nightclub or
Not at
something
all.
like that.
Community board supports, no problems.
Yes, so with those caveats, and that distinction from the case that we just heard, then I would vote to approve.
Enter.
So we are. Only voting and deciding the issue limited to that first issue.
Okay.
Okay? That is because the door that is in question within the 200 foot is only used to not making a determination on the food.
Okay. I'll take a win however I can get one.
Vote to approve this.
Okay. Thank you, members.
Thank you. No, the name does not need to come back.
So we do have an interpreter on the line with us, and I believe the
Okay.
attorney licensee's there. So calling up 1200 Jericho Palace Inc. It's a request for reconsideration.
What's that? 1200?
Good morning, Neil. Good morning, Neil Trivedi for Jericho Palace. I have with me the owner of the premises, Sapna Grover.
And we do have the interpreter. If Ms. Rupreet can introduce herself.
Hi, I'm Preet, and I'll be interpreting from English to Hindi to English for Ms. Sapna.
We need to, doing this online, Mr. Trivedi, we need to so if you can say a little bit at a time and then pause so that the interpreter can then interpret.
Okay. Again, Neil Trivedi, I have here on behalf of Jericho Palace, Inc., Sapna Grover.
So I do whatever is being sent, say to Sapna, right?
Yes.
Okay. Can you repeat, Mr. Trivedi?
My name is Neil Trivedi on behalf of Jericho Palace, and I have here the principal owner of the corporation, Sapna Grover.
मेरा नाम नील त्रिवेदी है और मेरे साथ ओनर हैं जेरिको पैलेस की सपना त्रिवेदी.
Sapna Grover.
Sapna Grover.
Yes. This is, I think, before the board because there was a default on the Jericho Palace, the notice of pleadings. I had made a motion for reconsideration. The date on that notice of pleadings was August 2nd. I had faxed in my response on July 17th. I have a confirmation receipt of it saying that it was received. And then subsequently, there was a cancellation order of it. And then I had made a motion for reconsideration. So I would like the opportunity to be heard at a hearing officer.
I would vote to reconsider. No problem with that.
अगस्त 2 को जो भी डिफॉल्ट आया था हमने दोबारा से उसको रिकंसिडरेशन के लिए भेजा था और अब हम बताना चाहेंगे कि दोबारा कंसिडर किया जाए हमारी प्लीज।
Chair, would you like to vote on reconsideration?
Yes, I'm gonna vote to reconsider. I'm gonna send this back to council's office.
Okay, thank you.
वोट हम दोबारा से इसको ऑफिस काउंसिल ऑफिस में भेजेंगे फॉर रिकंसिडरेशन, दोबारा से कंसिडर।
Thank you.
Okay. Okay.
All right. Thank you, Mr. Freed.
Thank you. Have a good.
Thank you.
You can sign off whenever you're ready. Next is 1197 SP PATCHOGUE Inc. Ergology. Introduce yourself, please.
Yeah, morning. I'm Patrick DeLuca. I'm here with my client Gus Burkettis regarding the notice of pleading.
This is your restaurant?
Yes, ma'am.
You run it?
Yes, ma'am.
Do you close the kitchen at 11?
It's based on volume, but on the day in question, they closed it a little earlier, unbeknown to me.
So what time do you close the kitchen?
We base it on volume. Usually when we do last call, then we'll close the kitchen at that time.
So there's no live music allowed, right?
No, ma'am.
And then, but you were using live music?
Well, we use, Spotify or whatever is depending on the day, but mechanical.
It's a chain,
It's family owned.
but you have multiple locations.
No, my uncle does.
You're the licensee on this location?
Yes, ma'am.
You own this franchise?
I own this myself, yes.
I see. Right. What's the allowable method of operation?
These
It's all,
We have them as a
Commissioner,
restaurant.
Chairman, recorded DJ, jukebox, and karaoke. They're all allowed.
Wait, what? Say that again?
It's recorded, DJ, jukebox, karaoke, and live music are all allowed.
And a licensed patio deck. Yes,
Yes.
yes, sir.
And what are the hours?
We don't have.
It's to 4 a.m.
Yeah.
Are the members ready to vote, or do they have any further questions?
It's important to note that the manager that was on duty that evening is no longer with the restaurant because that was part of the problem. And all the other issues listed have all been addressed. We have pictures to show the new signs and everything. And my client has been in the licensed restaurant business for 23 years. And he has no adverse history prior to this.
Okay. Right. Don't close the kitchen until.
We
right
found out the
before
hard way,
us.
yeah. Understood.
Don't overcrowd. I don't want to hear from the police. Thank you for coming in. I'm gonna accept 5,000. I was gonna go higher, but I'm gonna respect that this is a family business and that you need to get it under control because it's a chain. You don't want to mess up your whole brand.
Yeah,
because of
thank you,
one
ma'am,
location.
yes.
So I'm gonna accept 5,000.
I will accept 5,000 also. Thank you.
Thank you.
Thank you. Appreciate it.
Have a good.
All right, next is 1208 Tequila and Mezcal, New York Corp.
What's the name?
1208.
1208.
1208.
Okay.
Okay, Thomas Burke from the Law Office of Stacey L. Weiss.
Just cancel, right?
This license was canceled quite a while ago.
Yeah, cancel for the record. Thank you, Mr. Brewer. What else you got?
The next 1205.
1205 CAVALI, New York, Inc.
Once again, Thomas Burke from the Law Office of Stacey L. Weiss. And with me is the licensee, Farah Rosvi. You
1205.
sent us an offer of $2,500 to settle this matter. And it seems now you would like to withdraw that.
Yeah, I was actually gonna dismiss this. It seemed like it was spontaneous. Like the patron got hit, like she can't.
And the police refused to take a report at the scene. She came back a day later. There's no VIP room where she claimed she was hit.
I don't think it's a problem. Is that okay or not really?
Just give me 1 second to refresh my memory.
The police report indicated there was a brawl inside and that the woman struck in the face as a
Right.
result of the brawl. She walked into the precinct several hours after the incident. Cooperated with the police
Yeah.
department.
We offered 2,500.
Yes.
No arrest made in this case, Mr. Burke?
No, absolutely. I think that the 61 was classified unfounded.
Okay. I will accept that representation. You want to dismiss?
No.
Thank you, members.
All right, next is 1218 VINOLOGY Wines and Liquors, LLC. 1218.
Good morning. Francis Buscemi of Mailer and Buscemi for the applicant. With me today is Rowan Babatzinov and his wife Lana Bedels. This was put over, Chair Fan, from last time.
Are you okay with this one?
Yeah.
You saw the report from?
Yeah, I got, that's 1205. This is 1218.
Should I continue?
No, just give me 1 moment.
Sure.
Give me this one. I got 1220, 1217.
That was it.
Yeah, and I believe I sent him, let me see if I sent.
So it was just a liquor store. The prior tenant passed away.
Mm-hmm.
And then,
There was an investigation to see if it had been opened? or-
yeah, just to look at the
Uh-huh.
sale records and all of
Mhm.
that. So.
Yeah,
The
yeah, yeah.
investigator's report was added
Yeah.
as a supplemental.
Yeah, I see it. I believe, I thought I sent an email about it, but I see it on Chair Fan's screen.
So basically, he's just replacing a vacated.
I'm
store.
fine with it, I'm fine. with it.
All right, I'm gonna vote to approve. Thanks for waiting.
And Commissioner, you voting for approve?
Delia, Commissioner?
Yes, I also vote to approve.
Oh, okay, thank you.
Yep, thank you.
Congratulations.
Thanks for giving us time to look at it.
So next is 1219 and 1220 Sherry Lemon, Inc.
Good morning. Chair, Commissioner.
How are you?
Good. How are you? Thank you. Well, my name is Nicholas Bergman, and I'm an attorney with Buckman Law Firm here on behalf of the client. There are two matters before you, I believe. I'm here to answer any questions you may have about those matters.
I don't have any questions. Is the store open?
It is not right now.
It is not.
It is not.
It is not. Then you need to put it in safekeeping.
And thank you, and duly noted, and totally understand they are ready to open as soon as the construction out front is settled, which could be any day.
Yeah, but this has been going on. We've been asking you to put it in safekeeping since, I don't know how long, since July. That was why we had this problem, so it's silly.
One of the issues has been just getting kind of the city who's managing this construction to just finish off the job. It seems to be pretty much done, but again, there are things that I guess have to be finalized. So the hope is to just be ready to go into action and open as soon as that's done, rather than going through the process.
I can't have you be continuing to be in violation, right? So like, if I settle these today, then you're in violation in theory today. Even if you pay the 5,000, in theory, I send someone out tomorrow, I write up the same charges tomorrow. So what do you want to do?
We'll follow your direction.
Want to hold it over again?
No, I want you to either keep it, I don't know why you would, I don't.
Again, it's unfortunate timing with this, because of the construction being run by the
I
city.
understand
Yeah.
when things are inexplicable. I get it.
And it could take a long time to get the license back out. And so just administratively, we're
You don't
hoping to
trust
avoid that.
us?
Oh, no, man. It's
you
just,
serious?
it just, the hope is to be able to open like immediately.
Safekeeping that you not get it back, that's funny.
Correct.
Fair enough, you don't trust us. You'd rather pay than to trust us. I don't know how I feel about that. All right, I'm gonna accept a letter of warning for 1219 and $5,000 for 1220. Thank you.
Okay, I agree.
So do you want them to make them,
They need to put it in safekeeping if they're not open.
Safekeeping, Mr. Bergman. Safekeeping.
I will relay that to my client. Thank you very much.
Thank you.
You might see an investigator again. All right. Next is 1223 NYL Diamante Corp. Prima Donna Restaurant. 1223.
Good morning. Good morning, everyone. My name is John Mitchell with the firm of Mitchell in Cantalupo. This is my client and the owner, Christian Torral.
So we asked you to come in because it's just the same issues over and over again. So what do you want to do?
So if I might just add, since that time, my client has pretty much now been involved 7 days a week, almost 24 hours a day, basically in the place. He has weekly meetings with his staff. He's instructed them. As I said, I don't think you're going to have to see him again with respect to any of the violations. He's really taken hands-on charge. As far as the last two, it really was something that he did not realize that karaoke was considered live music. And since that time, I've made a FOIL request because I wasn't the one who originally submitted his license years ago to see what it says. And depending on when I get it back, I should be getting it back soon. We may be making an application just to have some live music. Not that he has live music, but from time to time, he will have karaoke. As far as dancing, really, he doesn't really want to have that at all. We do apologize for the fact that, yes, he did have karaoke, which is live music, and some patrons, although they weren't supposed to, did get up to dance, and he's instructed his staff that not to permit it. He's also put tables in every spot possible so that there actually is no room, even if somebody wanted to dance, for them to get up. And again, as I said, we do apologize. We made an offer. Hopefully, that's acceptable. And as I said, I don't think you're going to see him again with respect to any violations. And thank you for your consideration.
The license came in 2016. There are violations May 2018, July 2019, September 2019, November 2019, November 2019, November 2019 again, July 2020, January 2021, January 2021, June 2022, February 2023.
The most recent.
And one of them really concerns me. When you're violating maximum occupancy and you have blocked exits at the location, that is really a script for a disaster.
And that's why he's taken really, as I said, almost a 24/7 situation where he's there all the time now. He's instructed his staff, the security staff as well. He has, as I said, weekly meetings, and hopefully, I don't think, as I said, you're going to have any type of reoccurrence again. The most recent violation, the last one, I just want to add, was a very unfortunate thing. He had gotten a gift of a bottle of a very exclusive type of wine, and he just took it and put it in the back shelf, and you know, that's why that violation occurred. But he only does purchase from authorized distributors. So I just want you to know that. And as far as the other violations, as I said, I think they were a while ago. Hopefully they will not occur again. I don't think they will, because he has taken a hands-on operation. My client is a family man. He has 2 children, 2 young children. The business is his earnings, his livelihood. And he certainly is looking to make it a go and to have it a clean operation. He also serves food, very nice food, 24/7, whenever he's
He
open.
also serves food. He is a restaurant.
Yes.
You're acting like him serving food is him doing the authority of
Well,
labor.
what-
That's
no.
what he's licensed for.
Yeah, no, I understand that.
But he basically runs a nightclub, and you've mentioned nothing about DJs, but, you know, there
Well,
are videos online where he's basically running a nightclub, and that's why he's here. Like, this block of violations is not normal.
The DJ was not a regular occurrence. I think there was a birthday or something, whatever, and he had that DJ. But as I said, that's been discontinued completely. There is no DJ there anymore.
The DJ and the dancing. Okay. Just don't get into trouble again, because at some point we have to just say you can't have a business, and we don't want to do that.
You're not going to see him here again.
All right, I'm gonna accept 3,500, but
Thank you.
really live by recorded music only, okay? If you want a DJ, ask your lawyer, apply for it, and then get it.
Okay.
Okay, and I'm not saying I won't give it to you. If it's limited hours, there may be a chance that you can have what you want, how to entertain your guests, but you need to do it legally, okay?
As I said, we did make a FOIL request, so I can get the application to see exactly what it is, and we may be making that request, you know, for a DJ. And thank you for your consideration. Thank you very much.
Commissioner.
Thank you.
Yeah.
Anything
There is
further?
a lot of history here. My feeling is that the 3,500 is just, you know, a cost-benefit analysis, and I fear that the pattern of behavior will continue. And when you have dancing beyond maximum capacity and you have blocked exits, that is a real safety concern for me.
Absolutely.
So respectfully, I differ. I don't think 3,500 is enough to send a message here. I'm going to go with 6,000.
I'm sorry, I can't hear you.
6,000.
Yep. All right, so hold off, sir. Chair.
Could we possibly, Commissioner, could we possibly meet someplace in between on that?
That's up to the chair and the commissioner to decide, so.
No, I understand that. If that's a possibility, it's much appreciated.
5,000.
I'll go with 5,000.
I appreciate it. Thank you so much. Thank you. Thank you. Have a good day. Is that it?
Thank you.
Thank you.
Next is 1201 and 1202 Cafe Rum Limited. That's 1201 and 1202.
1201.
Francis Buscemi of Mailer and Buscemi for the licensee. With me is Emmanuel Pichardo. I'm sitting in for Mr. Mailer on this. This is a conditional no contest plea offer on the two cases of a civil penalty of $9,000. Just want to point out in the past, it's been about a year now, there's been no further issue here for this establishment.
They close at 11?
11 p.m. is the closing, yes.
Closing at 11, no background, no backyard use, and recorded music only.
Right. But the allegations are, it's recorded music only?
Full board steps.
So they're open on 11 o'clock.
I'm sorry.
What time do you close?
11.
He's adhering to his 11 p.m. closing, which is what the hour was set at when the application was approved.
I know, you just got the license in December of 21, and twice now there's violations of non-compliance with the method of operation that full board asked for.
Yeah, that's correct, Chair Fan. As I pointed out, in the last 11, 12 months, he hasn't had any further issues. He's adhering to his closing time.
Okay. The letter refers to COVID cutting into your revenue, but you were not open before COVID, or you had a different location?
No, I was doing construction on the COVID, but I just was struggling too much. Like, luckily me, I was able to open the restaurant.
In other words, it was, I think, what Mr. Mail is referring to, the delays in being able to get into business because of COVID, and it was taking, I think, a year to get his gas meter and stuff like that. That, you know, financially, he became very strapped. He extended where he shouldn't have extended on stuff like his hours. Again, he went back, it's 11 p.m. closing. He's been adhering to that. There was mention in the report, I believe, although there was these violations, the investigator did find that the premises was orderly, quote unquote. The location was orderly, so.
All right, I'm going to accept 9,000, but try not to get caught again, because it's just.
Thank you. I also accept 9,000.
All right, thank you. Have a good day.
Next is 1206 KMP Restaurant Corp. 1206.
Yes, good morning. For the record, on behalf of KNP, my name is Anastasio Sarikas, S-A-R-I-K-A-S. I'm the attorney for the corporation.
That's fine. You've removed him from the license, right?
Please repeat that.
You've repeat this one individual from the license.
That is correct. There's an application to have that individual removed. He was a 5% owner, but on September the 8th of 2022, there was a board meeting in my presence. I prepared the documents, which I believe you all have copies of, to remove him. And he has been removed.
Okay.
And we ask for this board's approval of that removal.
I think we did approve it.
Yes, it was approved.
Yeah, that was approved in August.
8/22.
Is there any other matter before
Well, we're just gonna accept the $1,000 now,
Yes,
and that's fine.
I-
Then you're good.
that would be fine.
All right, thank you.
Thank you very much.
All right.
I agree with $1,000.
All right, what's next, Donald?
And next is 1198 BRONXLANDIA LLC.
All right. Right. Hi, guys.
Hello.
Hi.
All right, so I was very delighted to see the letter come through from the community board. You're happy with what you agreed with them on?
Yes, ma'am.
Okay. I know there are some other issues that were outstanding, but considering that on our end, there are no pending charges, we're gonna let it go, but don't cross the line again. We're still going to ask you to do the metal detectors on the entry and adopt all the stipulations in the letter from the community board. Is that okay?
Yes.
Okay, so I'm gonna vote to approve.
Congratulations, and I also vote to approve.
All right, thank you.
All right, thank you.
Thank you.
Yeah. Oh,
Much happier experience this time around.
and the bathroom. I didn't forget about the bathroom.
They did the bathroom.
All right, next is 1217 GIANNI'S Restaurant Inc. 1217.
Good morning, members. Johnny Tello, owner of the Johnny's Restaurant Inc.
1,000 I will accept. Thank you.
I will, oh, hold on a second. Okay, I'll accept 1,000.
Thank you.
One, I think she wants to get her license. Can we talk to her?
Just have to send in the mail, right?
Yeah.
Thank you.
Who does? Who do I have to?
She wants to.
Yes.
There's something.
We'll go on a brief recess.
Yeah, let's
Yes.
just.
Oh, there with BRONXLANDIA.
One second, hold on.
Let's go, Donald.
All right, we're back on the record after a brief recess. Next is 1194 and 1195, J.P. Canes, Inc. 1194 and 1195.
Good morning, Terrence Flynn on behalf of the licensee. We submitted documents in support of the offer of compromise. I just want you to know that the licensee wanted to be here. His brother was a first responder at 9/11 and unfortunately has 9/11 illness, and he had to go down to South Carolina because he isn't doing that well. If you deem that he's necessary, he said he has no problem if you put this over. It's just that he could not be here today.
I'll accept 17,000.
I will also accept 17,000. Thank you.
Thank you very much.
Is that it?
Next is
I have one
1210. Yeah, 1210, Uncle Jack's of Bayside, Inc.
This is an offer of compromise to resolve the charge.
1,000. I'll accept. Thank you.
Thank you very much. Have a very nice day.
Thanks.
Hold on one second. So
I'm sorry, I apologize.
Did you accept?
1,000 is fine.
Thank you. Thank you very much.
I had to rush out of here. Next is 1221, Gray Dolphin Sports Bar and Lounge, Inc.
1221.
Good morning. My name is Jennifer Creighton. I'm representing Wilfred Wright. He's not here right now. So I was trying to get a lawyer, but the time was too short, and she called and left a message on the Mr. Forget his name, and the lawyer for the liquor authority, but she didn't get a response. So, because we wanted was to see if we could like put it off for today, so he could be here.
Okay, so you want to come back next time with your lawyer?
Yes.
Okay, so let's come back 11/8, and then you can come back here.
Abby?
November 8th,
Okay.
same time,
All right.
10 o'clock, okay?
Thank you.
Thank you.
Sure, you're okay with that?
I'm fine with that.
All right, and Jonathan, there's no one else there, right?
There's one more person here. What? Nothing, no items. He's just visiting. All right, let's go.
1196, this is an offer of 25,000.
I'm gonna take 25,000.
25,000 is okay.
And Commissioner, may I speak for a moment? I think they should file a corporate change application.
Okay, yes.
Not
I
done
will.
yet.
Okay, that's fine. I'll accept 25 and ask for a corporate change application.
I agree.
So really, it's a counter offer right now, but
Yep, that's fine.
okay.
I know.
All right.
there's no trust. Threw them all away.
Next is 1203. That's an offer of 8,000.
8,000.
8,000 is okay.
1204 is a no contest default at pleading.
This is the default and it's 37 cartons, so I am at, and they have a history. I'm at 6,500.
Okay, 6,500.
1207 is a package store removal application.
I'm going to vote to approve. What do you think?
I also vote to approve.
1209 is an offer of 1,000.
I would take 1,000.
I had a note on this one. It looks like this is a D felony. So enforcement needs to follow up to find out if the sole corporate principal is a prohibited person.
Yeah. Control,
Jamie, should we hold this over until we figure that out? Because we may be at cancel.
You
Wait, there's two
could,
different
or
charges for
we can
Jamie.
check to see what the
would be a different
disposition
charge.
was.
Okay, so let's
Yeah.
just, can we send a note to Joe Margarita and Jamie?
so what are we
Yes.
doing?
I'll accept 1,000 and then have enforcement follow up.
We're going to
I can
accept
send the
one-
email. Sorry.
We're just gonna accept the 1,000 for non-reporting, and then we're going to check and see if they're now a prohibited person, and that's a different charge.
Mm-hmm.
And we can cancel at that point, if that's what it calls.
Okay, it was a June 2022 arrest. I guess it could still be pending. So it's a 1,000. I'll agree.
1211 and 1212 is an offer of 6,000.
I'll accept 6,000.
Yeah, go ahead. 6,000's okay.
1213 is an offer of 4,000.
4,000.
4,000 is okay.
1215 and 1216, council's office asked to withdraw charge 4. This is an offer of 8,000. Oh, it's charge 4 in the second proceeding, and it's an offer of 8,000.
Withdraw charge 4 in the second proceeding, 8,000 I will accept.
I agree, 8,000.
1222, this is a new on-premises liquor application. No one showing up.
Yeah, I am gonna hold this over just one more time because this is a 200-foot case.
And you want them to appear.
So is that 11/8 or what are we doing?
Yeah.
So over to November 8th for the applicant to appear. Okay, Commissioner.
Yeah, that's fine.
1224 is a no contest default at pleading. They were asked to appear and I guess they have not.
We asked them to appear, right?
Yes.
Oh, this is the one in Schenectady. I don't know. I guess they're choosing not to come out. I'll just do 15,000.
Got an assault. Got a security guard, struck a patron with a baton.
We
Then
did
had a
warn
dog
them that it
attacker.
could lead to cancellation if they didn't appear, so I don't know if they cared.
Yeah, I would go with a cancellation and bond. Patron was stabbed. Yeah,
Chair,
but the
you were at
is the
15.
wife, so I'm
89 calls.
yeah. Go ahead.
What was that?
What's
Sorry.
that?
Oh, what
Yes,
was that? Did you change to cancel?
No, I didn't change to cancel. Are you at cancel?
I'm at cancel and bond, yeah.
Yeah.
Yeah, that's what I was just reading. This is an assault. A security guard struck a patron, then with a baton, had a dog attacker, and a patron was later stabbed. He's supposed to operate as a restaurant with recorded music, no DJ, no security. There are 89 complaints, calls about the place, and he just ignores us. So,
Did we, what's the record of us telling them that they need to come in?
So it should be in your packet. We did tell him, let me pull it up. We did tell him, so last time you said that it could lead to the cancellation of their license, and we made sure to note that. The new scheduled date is October 25th, 2023. You are directed to appear. Please note that we appear on the date
That's to
above.
his lawyer? Did we send that to his lawyer or?
Do they have an attorney? Because this was a default at pleading. So I don't think there was an attorney.
I don't know. Okay.
yeah, for me, there's just too much there. For the guy to completely ignore us, no. That'll get his attention. He'll come in when that happens.
Yeah, but like we're closing the business today if you cancel right now.
Yeah, and I understand.
All right, I'll cancel.
Next is 1226. It's an offer of 2,000.
I'm gonna accept 2,000. But again, Joe needs to follow up just to see what the disposition is, please.
Yeah, the principal here was arrested in August of 2021. His attorney said he would get back to us. We have no details provided. And I fear if this goes back that far, I fear that he's just not going to respond. There's no reason to.
The attorney was here before, and he advised that the wife is going to be attempting to transfer her name because he's not
Capable of
Yeah,
holding it.
there are problems right now, so with him, so
It's-
she's going to be processing.
Okay. You want to hold it over and give him a chance to come in and explain himself?
I mean, the attorney was here. I'm surprised he left Mr. Trivedi. He was here earlier.
Yeah, he's leaving it to us.
Look, I don't know what.
Mr. Trivedi indicated there's one matter that's still pending in criminal court.
Mhm.
That he has a criminal lawyer. I don't know what happened to all these other.
About this case or not the other case?
He said one matter. He didn't tell me whether.
He didn't say which one, right?
There appears to be an issue with.
Yeah, I would say so.
Yeah.
All right. Short of canceling and bond, how do we get this person's attention? This is 2021. We are now in 2023. That's 2 years. We fine them, it's going to be another 2 years if we ever get a response. Any ideas? Don, you have any ideas?
No, but we can go look, right? I mean, the enforcement will follow up.
I mean,
We just take the money and then enforcement will find out what the disposition of the case is.
Yeah, they can get a certificate of disposition from the court, and then they can find out if there's been a certificate of relief issued, if that's something that is needed for them to continue. And then they can write up a report and forward it. That'll be a new charge. If it's a felony and there's no certificate of relief, then it's a prohibited person.
All right. I get that. But I think we want people to know that they have to respond. That's not asking a whole lot.
Yes.
You need to respond. And don't throw the onus on us to figure out, your situation. You have an interest in this license, so you should make yourself interested. All right, I won't cancel, but I'll offer 5,000. I think 2,000 is not enough to send a message.
What's in the delegation?
what, it's a second charge. It's a second one, so it's not in the delegation. technically.
What's the first one in the delegation?
It's 1,000 typically.
And this one is now at 2?
I don't know, how,
Two similar arrests for violations of orders of protection.
oh, is that what it is?
Yeah,
Oh.
so there's, here. The wife wants to take over the licenses because of these
Ah,
issues.
Yeah, there's drama going on, I don't know. I'll go to 2,500.
I don't think he cares. I really don't think he cares. And I'm a little concerned about us sending a message that, that's all right. You don't have to get back to us. We'll work our way through it. I know that we want people to have businesses. We want them to be successful in their businesses. We want to be of help any way that we can, but we need their cooperation. And I just don't see this gentleman as cooperating. I offered 5, you offered 25. I'll go to 35. 3,500.
All for this to be
Thank
taken
you.
care of.
Maybe that'll get his attention.
If they don't respond to that, it'll go to a hearing where if they don't respond again, it'll be default and come back. Next is 1227 is another default at pleading, no contest default at pleading.
Cancel and bond.
1220.
Where you at?
This is 1227, yeah. C and B, yeah, cancel and bond.
All right, cancel and bond.
So next is 1229. So this one, we got an email from the attorney. They're asking either for an adjournment or actually, I think, to return to counsel's office. Is that right, Jamie?
Well, which one is it?
They wanna
I think
do
it was.
On Beach House? I didn't see an
Detail.
email. I apologize.
Oh, was that not you on that? I thought it was.
No,
Sorry.
it
Okay,
is.
so
Yeah, there was an
They
email.
wanted,
I
they
think.
wanted to put in a new CNC. That's what they wanted to do.
Okay, well, it's going back to Jamie. So Jamie, will you take it back?
Sure.
All right. Third that. All right, thank you, everybody.
Did we,
Yep, I
did we
have
do
that.
1220? We did
Thank you,
1220?
Donna. I thought that
Sorry?
worked out pretty well, actually.
Did we do 1220?
1220. 1220.
Yeah, they should have. I think that's one of the people that appeared was 1220. Yes, that was
1220? Okay.
Sherry Lemon. Sherry Lemon.
Oh, that's right. Yeah. Got it.
All right.
Yeah.
Meeting's adjourned. Thank you, everyone.
Great.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.